what is the after-death administration process? When someone dies, what are the big picture steps of what needs to be done? I'm Freeman Green with Freeman Green Law, and let's take a look at that. So, when a person dies, and we're looking at doing an after-death administration, there are a number of different steps that need to be taken. And those steps are often different from case to case, depending on the person's situation and their assets at the time of death. But in general, there are some big picture steps that need to be taken care of in an after-death administration. And most of those small steps that will vary from case to case are going to fall under these big picture steps that we'll go over. So, first, big picture step number one, when a person dies, we need to identify and value all assets and liabilities of the deceased person, and we value and identify all of those as of the date of death. We call these date of death values. So first, how do you go about identifying a person's assets? Well, if they have an estate plan in place, you'll want to take a look at the estate planning documents, and often with the estate planning documents, there will be some financial records or perhaps a list of the different things that they own. If the person was represented by an attorney or if they had a CPA, you can talk to the attorney and the CPA to see if they have a record of what the deceased person owned. Another thing that you can do is you can monitor the deceased person's mail to the extent that you have access to their email or you are aware of communications like that. You can monitor that and look for evidence of assets through email or conventional mail communications. Sometimes if the assets we're looking for are assets that would have a public record associated with them, like land or a business interest, we can search for those online. And in some cases, you might even hire a private investigator to do an asset search and see what assets they can identify. But regardless, you need to do your best to identify all assets and liabilities that the deceased person owned on the date of death. And then you want to get a good, solid, documented date of death value for each of those assets and liabilities. That's important for a couple of reasons. First reason has to do with tax. So when a person dies and they own an asset in the United States, if that asset has capital gain, for example, perhaps they own some Apple stock, and the stock has gone up in value since they bought it. That increase in value is a gain, called a capital gain. And if the stock is later sold, you'll pay capital gain tax on that. Well, when a person dies and they own an asset with a capital gain built in, usually that asset will have the gain erased. And if the asset were sold shortly after death, there would not be any capital gain that's reported and there wouldn't be any tax paid. So in other words, valuing the asset and knowing the date of death value can be important because that can document the asset's value and the fact that the gain has been erased. Another reason why this is important, especially in Oregon, where we have a very low estate tax threshold, which comes in at all estates with a value of $1 million or more, can potentially be subject to estate tax on assets. So we need to determine whether or not we need to file an estate tax return, and if a return is required, we need to file that return and report on the assets and the date of death values. And so to identify assets and then to value them, typically what we're doing is doing things like for bank accounts, we're getting account statements. We are getting appraisals on land or on real property, and we're having those assets appraised as of the date of death. And in general, what we want to do is just to go asset by asset, everything that the deceased person owned, and get a solid documented date of death value. You don't have to itemize every knife, fork, and spoon. For things like general personal effects, what we'll do is just estimate a garage sale value. We might say something like, it's estimated that all assets in the home, personal effects, are worth $2,000, or whatever a good faith estimate would be. Once you've identified all of the assets and liabilities, then the next step is to go about satisfying the liabilities. Anything that the deceased person owed that's a legitimate debt ought to be paid using the assets that they owned. Only a person with legal authority can do that, and that is going to depend very heavily on the documents that the deceased person had in place. If they had a trust in place, then much, if not all, of the legal authority will fall under the trust. If the person had assets that were required to go through probate, then a probate will need to be opened with a local court, and then a personal representative appointed by the probate court will have the authority to handle the assets and do things like pay off any creditors that are owed. Liabilities vary widely. Standard things like utility bills, final health care bills, and so on would need to be paid. And, very important, don't forget to file a final income tax return for the deceased person. What happens if you think that their income is low enough that they're not required to file? That's okay. Talk to an income tax professional like a CPA and have them tell you that, and then document that that's the case so that you could show why a final income tax return was not filed. That will take care of the deceased person's final income tax return obligation, but there's often an additional income tax return that needs to be filed. And that income tax return reports on any income that was received during the administration time. And that income tax return is filed on a Form 1041. You're used to seeing a Form 1040 probably when you file your income tax return each year. A Form 1041 is the income tax return form that's used for trusts and estates and is used very frequently in after-death administrations. It reports on any income that is due. This is a specialized type of return, and you want to make sure to work with a CPA or a tax professional that is familiar with these and that does them frequently to see if that needs to be done, and if so, to make sure that it gets filed. We talked about the estate tax just a little bit, and that is a liability that you want to make sure is taken care of as well, if required. In the state of Oregon, if the estate is at or over $1 million, then you want to be sure to file an estate tax return. And then estate tax would be paid in general at a rate of anywhere from 10 to 16% on assets in excess of $1 million. So, once we've satisfied liabilities, it's then time to distribute the assets. This is important because this is where the beneficiaries inherit. And if the deceased person has left a will or a trust or beneficiary designations or combinations of those things, we need to make sure that those are followed and that the correct people inherit the assets. Distributing assets can be as simple as just writing a check to distribute the cash if what we're distributing are cash assets held in a bank account. For physical assets like land, there would be something done like a deed to transfer title to real property and land assets. Things like personal property, when they say possession is 9/10 of the law, there's some truth to that. And generally for personal effects, it's just the transferring of possession then that conveys ownership. But you can do something called a bill of sale to show and document that those personal effects have been transferred to the rightful beneficiaries. So asset by asset, these get distributed to the correct beneficiaries. Then, once the beneficiaries have inherited, it's important that they review their own estate plans. if they don't have an estate plan in place, this is a good time for them to think about getting an estate plan in place. If they do have an estate plan in place, they need to make sure that the assets, as they are transferred, that they're transferred into their living trust, or that beneficiary designations are put in place as appropriate. This is very specific, and you want to make sure to talk to the estate planning attorney about how to handle that correctly. A common question that I get when folks are inheriting is, well, do we have to pay inheritance tax? Or do we have to report these for income tax purposes? Very important that you get specific advice from a tax professional on that. But in general, what happens is that estate tax is paid by the will or the trust or the person that's handling those things. That gets paid off the top, and then the beneficiaries inherit what's left. And in general, what they inherit free of estate tax or income tax. An exception to that are assets where the deceased person never paid income tax on them to begin with. These would be tax-deferred assets like an IRA or a 401k. Those are special types of retirement accounts that they're pregnant with income tax. The deceased person never paid income tax on the assets put into those. And so later, if someone inherits them and the assets are taken out of the IRA or the 401k, then it becomes income to the beneficiary that receives them. So those are the big picture after death administration steps. Again, there will be many smaller steps that fall within these. And if there's a trust administration, or if there's a probate administration, or both, those will each have their own special nuances and steps that need to be taken. So those are the big picture after death administration steps. Thank you for watching. I hope that was helpful to you. If you think that video might be helpful to someone else, please feel free to share it with them. And if you think that our law office might be able to help you with trusts, probate, or estate planning, please feel free to contact us. Thank you.